So very good evening, all the participants. Today we have with us Vijay Kumarji, who will be taking us through the provisions regarding fast track, and I will be intervening wherever required. So, as the name itself implies, it is fast track, but it is fast track corporate insolvency resolution process. It is covered in part 2. So, it is applicable both to companies as well as LLPs. But since it is a fast track, so there are definitely sections and regulations for this fast track process. But can anybody tell me whether there are any rules also? Like in CIRP, there are application to adjudicating authority rules. So in case of fast track also, are there any rules? Or the rules which are applicable to CIRP process, they shall be applicable to this fast track also. What is your view on this? This is the first thing you should be clear about. If you see the particular forms, suppose you see the form of financial creditor, or you see the form for initiation of CIRP by an operational creditor or the corporate debtor. So there it is taking you to chapter 4 also. This is covered in chapter 4. So the application form for initiating either the normal CIRP or this fast track is same. So that is the reason there are no separate application to adjudicating authority rules for this fast track process. But are there regulations? Yes. Regulations are there. I have shared in this PPT the section as well as the regulations. In regulations, I have already put in bold wherever there are changes or wherever there are important issues. So now I would request Vijay Kumarji to please proceed. Vijay Kumarji, please.
Yeah.
So what we can do is we can do it on slideshow mode. Just press slideshow and
okay.
Yes.
Okay, sir. 1 minute.
Yes.
Yeah.
Slideshow and
you are okay now?
Perfect. Perfect, sir. Perfect.
Yeah.
Please start, sir.
Yeah. So good evening, gentlemen, and welcome all of you. And thanks for joining this evening. And thank you for our mentor R.K. Gupta. And with his permission, I run this slide presented by him. And this is the fast track corporate insolvency resolution process, as the slide says, regulation 1 and 2. And section 55.
So just to add here,
yeah.
So since I have mentioned regulation 1 and 2, so that means this section is to be read along with regulation 1 and 2.
Yes.
If you read it from the book, you will not find this noting there, regulation 1 and 2. So wherever any section has some relevance to some particular regulation, so I have linked that.
Connected it.
Yes,
You are connected it now. You are connected it.
Yes.
So that we can remember both as well as section and the regulation comes to our mind, and it is well connected. So section 55 says corporate insolvency resolution process carried out in accordance with the particular chapter, and the chapter 4 it is called a fast track corporate insolvency resolution process. Point number 1. So we get two things. One is regulation 1 and 2. Chapter is 4. And we also say that anything you do with this particular section, we are going to read 4 or 5 sections. So this is covered under chapter 4, and it is called, whenever we talk about this section, it means fast track corporate insolvency. An application for fast track corporate insolvency may be made in respect of the following corporate debtors, namely corporate debtor with assets and income below a level as may be notified by the central government. Number 2, corporate debtor with such class of creditors or such amount of debt as may be notified by the central government. So central government, basically MCA making a notification on behalf of the Ministry of Corporate Affairs, make this thing here. And see, there is a message, Harish entered the waiting room. So let us admit him. Yeah. Welcome, Harish. So here we are seeing two classes of corporate data with reference to their assets or income below a level, which will be notified by MCA, that is central government. Corporate data with such class of creditors, such amount of debt as may be notified. Such other category of corporate person as may be notified by the central government. Sir, would you like to add
So
anything?
yes,
And
just I would like to add one thing here, that you may be interested whether there is any such notification. So regarding this 55(2)(a), regarding the corporate debtor with assets and income, as of now, there is no such notification. Second point, corporate debtor with such class of creditors or such amount of debt, no notification till date. The only notification is regarding the other category of corporate persons. So there are notifications, more than one, on this, such other category of corporate persons. And those notifications also I have already put in this PPT, which has already been shared with all of you. Please continue, sir. 56.
So now we are going to go section 56 of the IBC code. And now you know that who is the corporate person that will be notified by the central government is 55. 56 talk about what is the time limit or a time period for completing this fast track resolution process. Subject to the provision of section 3 in the same 56, subject to the provision of subsection 3, the fast track corporate insolvency resolution process shall be completed within a period of 90 days from the insolvency commencement date. You all know that normal time is 180 days, right? In the corporate insolvency process for a corporate person, we all know that 180 days minimum, right? Plus 90 days, one extension can be given, one-time extension only. You cannot go to second time or a third time. So which means 180 plus 90 days we know for a normal insolvency resolution. But this fast track talks about 90 days. Okay. Second provision is the resolution professional shall file an application to the adjudicate authority to extend the period of fast track insolvency beyond 90 days if instructed to do so by a resolution passed at the meeting of the committee of creditors and supported by a vote of 75% of the voting share. Now you can know that 90 days is a prescribed time limit for the fast track corporate insolvency, but that such times can be extended. The power to extend the time is rested with the committee of COC, we call committee of creditors, and you need a support of 75% of the voting shares of the COC, then only this is possible. Now, number 3, on receipt of application under subsection 2, if adjudicating authority is satisfied, the subject matter of the case is such that fast track corporate insolvency cannot be completed within a period of 90 days. It may, by order, extend the duration of such process beyond the set period of 90 days by such further period, which in their wisdom, they may add 30, they may add, but not exceeding 45 days can be given. Okay. So now you also understand not only the committee of creditors can extend the timeline with the 75% voting shares, but it can also be extended by the adjudicating authority at the time of filing an application. In their wisdom, they think 90 days is not sufficient to handle this case. They can extend maximum, they can extend any time, but subject to a maximum 40 days. Provided that any extension of the fast track corporate insolvency under this section shall not be granted more than once. Regulation 39, you all know that it's the same for insolvency resolution, normal insolvency resolution for corporate. So I leave it to Gupta ji to add value.
So I would like to add here that section 56 corresponds to section 12 of the CIRP process. Section 12, as we all know, talks of a time period of 180 days with one-time extension, maximum up to 90 days, and then covering the litigation also 330 days. So that is the time period in case of section 12 in normal CIRP. And for extension, you require a approval by COC with 66% share. So there are two, three aberrations here in section 56. So in section 56, 90 days instead of 180 days. One time extension of 90 days there. Here one time extension of 45 days. There is no concept of 330 days here as in case of normal CIRP. And the percentage also is changed from 66 to 75%. You might be wondering why it is here 75% and not 66%. The reason is there is no change in the fast track regulations since a long time. So after 2018, there is no change. So that is the reason they have not, maybe that sometimes when they rearrange the code, because if whatever they write in the code, so it requires approval from the parliament, both houses of parliament. So that is the catch here. Had they written this thing in the regulations, they might have amended it by now. But here they have written it in the code. So once a thing is written in the code and there is no amendment in the code since 2021, August 2021. If they want to change it, so they have to route it through the parliament. That is why they have not yet changed it. Yes, please. Please carry on, sir. Section 57.
Yeah, yeah. So now, 1 minute, I will put it to the
Slide
so
show.
yes. Yeah, manner of initiating fast track corporate insolvency is section 57.
Yes.
We have
Vijay
seen
Kumar ji, you
55,
can put it on
56.
slideshow mode.
Yeah, sir, I have already put it on a slideshow.
Okay, okay, okay.
Okay, 1 minute, sir. I have already put it, sir. Can you see that properly?
Yes, 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 we can see it. Yes, please.
So, manner of initiating fast track corporate insolvency resolution process. An application for fast track insolvency resolution process may be filed by a creditor or a corporate debtor, as the case may be, along with the proof of existence of default, as evidenced by records available with an information utility or such other means as may be specified by the board. The board refers to IBVI. And such other, this is additional condition, additional things that you got to do is such other information as may be specified by the board to establish that corporate debtor is eligible for the fast track corporate insolvency resolution process. Manner of initiating corporate insolvency resolution process. Okay, that is 57. So, sir, would you like to add something there before
There
I go to
are, I would request all the participants to please open the application to adjudicating authority rules for CIRP process. Application to adjudicating authority rules. So can you open it, Vijay Kumar ji? Do you have those application to adjudicating authority rules?
I don't have, sir.
Ajay ji, do you have it? The point is, this way I will be able to gauge your preparation level also and what is the material you are having. Ajay Jaswal ji, I hope you must be having.
Yes, sir. I'm trying to open, sir.
Yes.
So I will stop share.
Yes.
So this is we are talking about the regulations, right, sir?
No. We are talking about application to there are two things. One are rules. Second is regulations. So whenever the word prescribed is used, it is referring to regulations. So I am requesting you to open application to adjudicating authority rules for applicable for CIRP process.
This is rules.
Yes. It is available in the index also, which I have given. The PPT, the bare code PPT, which I have given it to you, that is available. And there is, I have provided you index also. So from the index, you can easily find out.
One second, sir.
No issues. Please take your time.
Please.
Or anybody else who is having. Anybody who is having application to adjudicating authority rules. So I can make that person as co-host and he can share it. अजय जी मेरे वाला पीपीटी होगा ना आपके पास?
Yes, मैंने खोला है, मैं वो उस पेज पे जा रहा हूँ।
हाँ, slide, हाँ. तो व्यू में जाके स्लाइड सॉर्टर पे चले जाएंगे ना, तो 4-4 स्लाइड इकट्ठा करेंगे तो।
इंडेक्स में ढूंढ रहा हूँ कहाँ पे है।
हाँ हाँ हाँ
पेज
हाँ
नंबर 161 पर है वो
हाँ,
पीपीटी में 161।
वेरी गुड।
Okay.
इससे पता चल जाएगा। देखो मैं तो शेयर कर ही दूंगा, आपको पढ़ना ज्यादा जरूरी है ना, मुझे ये बात है।
एक्चुअली आई प्रिफर बुक्स, तो मैं ज्यादा
नहीं
गया।
कोई बात नहीं, कोई बात नहीं, हाँ हाँ।
161, राइट?
हम्म।
Yes. So I'm sharing this.
हाँ स्क्रीन, यस। Okay, so this is the application to adjudicating authority rules. Now, in this, I would request you, suppose you are a financial creditor. So, which form you will be using for initiating this fast track process? Fast track के लिए, if being a financial creditor, है ना? And one more thing, whether the default amount is same or default amount is different. This is another question. Yes, Vijay Kumar ji. Default amount for normal CIRP and default amount for fast track, whether it is different or it is same.
Sir, it looks same, sir.
Yes, it is same. It is very much same.
तो फॉर्म 1 इज
हाँ,
prescribed for
फॉर्म 1 खोल दीजिए। हाँ जी, हाँ ये फॉर्म 1 है। तो इन फॉर्म 1 वेर यू विल फाइंड दैट दिस इज एप्लीकेबल टू फास्ट ट्रैक। एनी आइडिया कहां पर लिखा है ये बात?
under the chapter 2 of part 2, that is mentioned there.
कहां?
The application by financial creditors to initiate corporate, this is for initiation of corporate CIRP actually.
नहीं नहीं नहीं, आप भी देखो ना, अंडर चैप्टर 4 भी तो लिखा।
Chapter 4, it is chapter 4.
इसीलिए आई वांट टू स्ट्रेस दिस पॉइंट कि भाई अब सपोज आई एम टेलिंग यू समथिंग, तो आई शुड बी एबल टू कन्विंस यू ऑल्सो ना कि भाई चैप्टर 4 क्या? चैप्टर 4 इज फास्ट ट्रैक।
Yes.
लिखा ना चैप्टर 4?
ये दोनों के लिए एप्लीकेबल, सीआरपी भी फास्ट ट्रैक भी।
दोनों के लिए एप्लीकेबल है। ठीक है जी, चलिए बस इतना ही दिखाना था और इसको ये समझाना था कि भाई यही वाला फॉर्म आपको यूज करना है। चलिए प्लीज बस इसको बंद कर दीजिए।
मैं स्टॉप कर देता हूँ।
हाँ, कईयों को पता भी चल गया होगा ना, कईयों को पहले पता ही नहीं होगा एप्लीकेशन टू एडजुडिकेटिंग अथॉरिटी रूल्स भी होते हैं कुछ। अब कम से कम देख तो लिया ना। चलिए विजय कुमार जी, प्लीज शेयर योर स्क्रीन अगेन।
Yes, sir. Yes, sir.
यस। और ये बात मुझे भी कई सालों बाद समझ में आई। व्हेन आई वाज टीचिंग दिस आईबीसी, इवन आई वाज नॉट अवेयर। I used to tell students that these forms are not yet notified for this fast track process. Then I came to know after reading it again and again that okay, this is the form. Yes, please. Just the slide prior to this.
Yes, sir. Yes, sir. Sir, can you see the slide now?
Yes, 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 yes. Just go on previous slide. Previous one. Previous.
Okay.
Prior to this.
Right, sir.
Yes.
So
So
now
we were
we
here.
have crossed, now we have crossed 57 IBC code.
Right.
Now getting into section 58, applicable
Yes.
to chapter 2 to this chapter.
हाँ,
The process for conducting a corporate insolvency resolution process under chapter 2 and the provision relating to offenses and penalties under chapter 7 shall apply to this chapter as the context may require.
So
So
they say
regulation
because chapter 2 it talks of normal CIRP. So they say the provisions regarding normal CIRP and provisions relating to offenses and penalties which are given in chapter 7, they shall also apply to this chapter. This chapter means chapter 4, which is talking of fast track insolvency resolution process. And related
the process-
regulations, they are given in regulation number 3 to 38. So up till now, we have seen a few things. Number 1, only a few classes of companies have been notified. We'll see it later. Another aberration is there is no concept of 1/2 of 330. There is a concept of 1/2 of 180, which is 90, 1/2 of 90, which is 45. Percentage is different here. Percentage here is 75. There it is 66 in normal CIRP.
Correct.
Here, there is no concept of financial creditor or operational creditor. They are referring to creditor or corporate debtor. But the application form is taking you, suppose you are a financial creditor, so then you will be filing that particular form, form number 1. And in case of operational creditor, whatever is the form, I think form number 5 or whatever is the form, so that you will be filing. This is the meaning. Yes, please. Please continue, sir. Next page.
So, next slide is section 55.
Yes.
For debtors with the debts below certain limit and certain class of creditor or as notified by the government.
Yes. This is just a summary of whatever we have read till now. Yes. Just one page summary. Yes.
Yeah. So we can go to the next page and
Yes.
We go to the next page.
Right.
So this is a process flow.
Right.
Right. You read from 1 to 10. Appointment of resolution process is a step number 1. Public announcement is a step number 2. So as a RP, as a IRP or a RP, that you should know how this proceeds, right? What is the steps? You should also be very clear. Appointment of resolution professional is step number 1. Public announcement 2. Submission and verification of claims, step number 3, which is normal for corporate, chapter 2. Formation of committee of creditors 4, meeting of the committee of creditors 5, submission of resolution plan with adjudicated. Sorry,
no, 6. Point number 6.
Appointment of register value is the next step. Drafting of information memorandum is step number 7, and formation of the resolution plan is step number 8. Approval of the resolution plan is step number 9. Obviously, 10th is the final step. You submit your resolution, plan to adjudicating authority for approval. So that's the last step.
Yes.
Yeah.
So here you might be wondering whether there are any timelines. So I have given you the timeline chart also.
Very good.
So please go to that chart, sir. Vijay Kumar ji, please go to that chart of 90 days.
Yeah.
No, here not. Just
next slide.
Next, dekh lijiye.
Yeah.
You just go to that slide particular which is talking of timelines.
Okay.
Yes. चलते रहिए, कोई बात नहीं. Then we'll come back. No issues. नहीं वो timeline you will get the timeline ना. वो आ जाएगा T+3 फलाना. Yes. Yes, please. Next करते रहिए, कोई बात नहीं. Yes, this is the timeline chart.
Correct.
Right.
So this is a timeline start and the commencement of CRP. Obviously, T, that is day number 1, and public announcement within 3 days. Submission claims within 10 days.
So here, like in CIRP, the time for submission of claims is 14 days. So here it is 10 days from the appointment of the IRP. So we have to remember the timelines also. And I have given you one IBC chart also, which gives comparison over various processes. So that chart also, I hope it is available with you. So
available.
Yes, please. Next.
So approval of resolution plans by the committee is to completed within 75 days from the commencement. And within next is verification of claims received under regulation 12.1 and verification of claims received under regulation number 12.2. So within 7 days from the receipt of the claim.
Right.
So which is T+17, T+82, no, T+7 actually, it's not 17. And totally now T+82 we have reached now. And the last point is report certifying constitution of the COC T+21. And
next page.
First meeting of the COC is T+28. A resolution to appoint RP.
So here there is another change.
Yeah.
In case of normal CIRP, the notice is 5 days, but here the notice is 7 days. So we have to just keep a track of the minor changes. So they might ask questions on this. Yes.
Yes, definitely they'll ask. So resolution to appoint RP by the COC T+28 days, and IRP performs the function of RP till the RP is appointed T+40. if RP is not appointed by 40th day of commencement, right? Next is appointment of valuer within 7 days of appointment of RP. This is a key take. Submission of application for withdrawal of application admitted before issue of EOI. Sir, I don't know what is that.
So that depends actually. Whenever that application is submitted for withdrawal, they can apply. Yes.
Yeah, COC to dispose of the application with from the date 7 days, within 7 days of the receipt or 7 days of the constitution, whichever is later. Next is filling of application withdrawal within 3 days, that is W plus 10. Yes.
Next.
Final list of RP within, that is commencement T plus
T plus
issue
10
of
will
RP.
It will be T plus 10. Within 10 days of the receipt of objection.
T plus 10.
So whatever is the time limit,
Yeah,
we'll
within
just 10 days to that.
Yeah, 10 days. Issue of RP, including evaluation matrix and IUP, is called within 5 days of the provisional list, issue of provisional list. Receipt of resolution plans, at least 30 days from the issue of RP, assume 30 days, T plus 60. Submission of COC approved resolution plan to executing authorities, T plus 75. Approval of resolution plan by IA is T plus 90. That's how the process ends there.
Yes. Now please again go back to that slide which we were referring. Yes.
Yes, sir. Yes, sir. Yeah. Sir, the next slide is initiation of fast track corporate insolvent resolution of corporate debtor or LLP, chapter 4 of part 2 of the code for fast track. This covers section 55 to 58. And, the companies covered is small company, startup company, unlisted company. And
sir, can you zoom it, sir? Because not visual, sir.
Okay, sir, can we do something about this? I think this is how it appears.
I think you already have a copy of the PPT with you, so you can open on your own laptop.
Okay.
I've already shared.
Correct.
Okay, sir.
It's there. Filing of application to NCLT along with proof of existence of default with the information or such other information as specified by IBI. We have seen that in 55 to 58. And the fast track application shall be completed within 90 days from the fast track insolvency commencement date. One-time extension of 45 days may be granted by the adjudicating or receipt of application by the RP. The process flow of insolvency under chapter 2 and the provision relating to offenses and penalties under chapter shall equally apply to fast track also, like it applies to the normal CRP process for corporate person. The same provision and the process flow will be same, like 1 to 10 we have seen. So the flow will be same, and penalty provision and offenses all that contained in chapter 7 will apply to us. So now we have a MCQ on fast track. Okay, so I think we have read enough. An application for fast track corporate insolvency resolution process may be made in respect of the following corporate debtors: small-sized companies as defined under Companies Act 2000, or startup company other than partnership firm, or unlisted company with the total assets not exceeding 1 crore as reported in the books of preceding financial year. Here asset mean WTV of assets, market value of assets, gross value of assets, none of the above. So that's a question, right, sir? Is asset means what?
Yes.
I believe there are two questions altogether.
Yeah. So here the asset means written down value of the assets is the right answer.
Yes.
Right,
Actually, IBC itself says that whenever any clarification is not there, or so then you can make reference to the other acts. So here there is a lot of reference to the Contract Act, Companies Act, etc. So section 3 subsection 37, if we read, section 3 subsection 37 says that Words and expressions used but not defined in this code, but defined in Contract Act, Partnership Act, SCRA, SEBI, RDB, LLP, Companies Act, they shall have the meaning. So all these things, most of the things, they are available in the Companies Act. So we can take a reference from there. Yes, please. Next.
Next. So this is new definition of small company.
Right.
Yeah.
So as of now, what we have to remember, we may not read the entire thing. The paid up capital
Correct.
requirement is 4 crores. So companies up to 4 crores, they can go in for this fast track process. Companies having paid up capital and turnover is 40 crores as of now, maximum. So if you are having a company which is having paid up capital of 4 crores, up to 4 crores, then you can go in for this fast track, and turnover limit is 40 crores as of now.
Yes. So we have two criteria: paid up share capital and turnover to
Yes.
get the fast track.
Yes. So this
So-
is about small company. Yes. Next slide.
Yeah, this is a maximum value, 4 crore and 40 crore. Please remember, it's a
Right. This
maximum.
much we have to remember.
Yeah,
And it is applicable for both old syllabus as well as new syllabus.
new syllabus.
Yes.
Second one is Ethan Desai.
We can skip this. They can read on their own.
Okay.
Yes. Next, please.
So benefits for small company under the
Yes,
Companies
yes,
Act.
yes. So this is relevant for the purpose of Companies Act because Companies Act is also in our syllabus. So the students can go through this. Okay, there are certain relaxations which are given to small companies. So it is relevant for that purpose. Yes, please. Next.
Next slide.
Hmm.
So small company defined in section 285 of the Companies Act means a company other than a public company whose paid up capital does not exceed 50 lakhs or such higher amount as may be prescribed, which shall not be more than 10 crores.
Yes. So the point here is that whenever you read the Companies Act, you have to read it along with the rules. In Companies Act also, there are rules. So you have to read it along with the rules. But because here you will not find reference to 4 crores. So you might be wondering where 4 crores is written. So they say it can be because the process of amending the act is more cumbersome. So naturally, every act they supplement it with the rules. So whenever they want to change, they will change the rules. So here also it is same. You must be wondering where paid up capital of 4 crores is written. It is available in the rules. And up to 10 crores, if they want to change it, they will simply change the rules and they will do it. But beyond 10 crores, then it will require amendment in the act, which is more tedious. So that is why in every act, this procedure is being followed. Yes, please.
Yeah. This is a minimum and maximum.
Yes.
So the maximum is prescribed in the rules. We will
Right.
not do what
As
is-
of now, which
what
may
is-
change from time to time. Yes.
From time to time, they will change
Yes.
it. So turnover, which is as per profit and loss account for the immediate preceding year, does not exceed 2 crore or such other higher amount as may be prescribed, which shall not be more than 100 crore rupees.
Yes. As of
This
now, it
where
is 40 crores,
come.
which is
This
applicable
where
for our.
40 crores come,
Yes.
which is specified in that. Provided nothing in this class shall apply to holding company or a subsidiary company, Section 8A company, company or a body corporate governed by a special act.
Mhm.
So now MCQ, here turnover means is what? Gross amount of revenue, operating revenue, sales, or any of the above. Reference section 291 of the Companies Act, it is gross amount of revenue.
Yes.
Am I right?
So, because they may ask you this question, but they are referring to turnover. So, turnover means what? So, for this, we have to again go back to Companies Act, which gives the definition of turnover, which is given in section 2, subsection 91. They can also ask you whether turnover is defined in IBC. The answer is no.
Good.
These are very small things, but you have to be careful.
Yes.
Yes, please. Next.
Next slide is as per section 55, an application for fast track corporate insurance process may be made in respect of the following corporate data, namely a corporate debtor with assets and income below certain level, a corporate debtor with such class of debtor or such amount as may be notified, or such other categories as may be. Now, the options are prescribed, notified, specified, any of the above. We all know that it is mentioned notified, right?
Yes.
Notified by the central government is the word we remember. So it's notified. Answer is correct. Next is, as per section 55, again, an application for fast track corporate insolvency resolution may be made in respect of the following corporate debtors, namely corporate debtor with assets and income below notified level, corporate debtor with such class of creditors or such amount as notified. Again, notified is mentioned. Such other clarity as may be notified. Whether any class of creditor amount has been notified. We all, Gupta ji told it is not been notified. Both A and B is not notified in the section 55. So the
Right.
answer
Only
is
C.
no.
There is a notification regarding point number C only. Yes.
C only. So answer B is the right answer.
Right.
Next, in this case, application was admitted by the AA, that is adjudicating authority, on 1/10/2022, when the 90 days period shall end. Okay. Now, answer is 29/12, 30/12. And
Now, what is the logic? The logic is they are referring T plus 90.
yes.
So, you have to add 90 days.
Yes.
And you have to consider whether it is a leap year or not. So, it is not a leap year. So, if it is not a leap year, then you have to calculate excluding this 1st of October. Hai na? So, in October, there are how many days? 31 days. So, 30 days of October. November, 30 days. And December, 30 days. So, what will be the answer?
30th December.
Because you have to calculate the number of days. And
Correct.
where it is written? It is written regulation number 40A of CIRP regulations.
Yes. So next slide, MCQ.
Yes.
As per fast track regulation, fair value means estimated realizable value of the assets of the corporate debtor if they were to be exchanged on the insolvency commencement date between willing buyer and willing seller in an arm's length transaction after proper marketing and where the parties have acted knowledgeably, prudently, and without compulsion. Liquidated value means estimated realizable value of the assets of the corporate debtor if the corporate debtor were to be liquidated on the insolvency commencement date. Which of the following statement is right? Fair value and liquidation values are different. Liquidation value is generally lower than the fair value. Fair value and liquidation value both are notional figures, none of the above. So the answer is fair value and liquidation value are different. Am I right, sir?
No, the answer is D here. I have just written for the explanation purpose that A is correct, B is correct, C is correct. The question is asking which is incorrect.
Oh, which is incorrect. Correct, sir. Correct.
So incorrect is D, none of the above.
None of the above. Okay.
And these are very basic concepts, but you must remember that these are all notional figures. Liquidation has not taken place. So this is just a guiding factor. These fair value and liquidation value, they are a guiding factor to the resolution professional or COC to assess the resolution plans. Because normally, although there is no such bar, another question is whether the value offered in the resolution plan could be lower than the fair value or liquidation value. The answer is yes. So it is not compulsory that the plan value should be always more than the fair value or liquidation value. But still it is considered as a criteria in normal parlance. So they will naturally would like to see, because the interest is maximization of the interest of stakeholders. So normally the plan value will be more than the fair value or liquidation value, although there is no such bar.
Okay.
Yes.
See, in this MCQ, I want to emphasize the ABC option is a fact. Meaning that fair value and liquidation value are two different values. Is that correct? Yes, it's correct. Liquidation value is normally lower than the fair value. It is a correct statement. And thirdly, you will also understand fair value and liquidation value both are notional figures because the event has not happened. It's only an estimate. Okay, it's only an estimate. Notional value for guidance. Therefore, all the ABC is a fact. So which we should keep it in mind.
Right. Please.
Next is as per fast track regulations. We are reading a regulations. Section 2.1. Section. Participant means person entitled to attend the meeting of the committee under section 24 or any other person authorized by the committee to attend the meeting.
Hmm.
Which of the following may be covered under any other person?
Hmm.
A board of directors, operational creditors or their representatives, if the amount of their aggregate dues is not less than 10% of the debt, register value, and insolvency professional appointed by the creditor. The answer
Actually,
is
there are three categories. Whenever
yes.
you are referring to the meeting provisions, there are three types of stakeholders. Number one, the financial creditors, basically unrelated financial creditors, or the operational creditors in case there are no unrelated financial creditors. This is the one category which are entitled for voting also. This much we know because we have read the provisions regarding CIRP. Second category is because RP will be convening the meeting, so RP will definitely be there. The past board, the suspended board of directors, they will also be invited to the meetings. But there could be some other persons also which may be authorized by the committee. They may be invited. Like in CIRP provisions, we have read that the resolution applicant is also entitled to attend the meeting in which his resolution plan will be discussed. Similarly, a valuer may be invited to the meetings of the committee. A forensic auditor may be invited. If they want, if the COC wants to discuss certain things with the forensic auditor or the auditor or the valuer, so they may invite such persons from time to time. So that is why they have given this residuary clause, any other person. But it has to be authorized by the committee. Because in meeting regulations, we have already read that no unauthorized person shall have access to the meetings.
In other words, board of directors, suspended board of directors, operational creditors in excess of 10% of the total debt, and insolvency provision by default are people entitled to attend the meeting.
Yes.
This is by default, right?
Yes,
This
they
is
are.
by
Yes.
default.
Yes.
So
But
here, any other
now the
person
point is,
obviously-
who could be else apart from this?
apart from this. So register valuer is a person in this particular MCQ. So
Right.
he can be invited, not only register valuer, you can invite a transaction auditor, a
Right.
fraud auditor, any special person who is a specialist, come and explain to the committee of creditor the basis for arriving.
Right. He
of
could
the
be a resolution applicant also.
Yeah,
So
he could
depending,
be.
this is just to give you
Yes,
an
yes,
idea कि what
Thank you.
type of persons, because they may frame questions on, because they want to analyze your basic understanding of the code. That is the point. Certain things are not written in the code.
Yeah. Whether this company will qualify under fast track process. Definition of small company as per section 285 means company other than a public company whose paid up capital does not exceed 4 crores. Balance sheet of expense as follows. Paid up capital is 4 crore and assets are explained, fixed assets, other assets, call in arrears, accumulated losses, all that. So the question is,
But वहीं पर ही question है वो. Yes.
so what is the question?
This is the question. Whether this company is well qualified?
Yes. Yes, this company will qualify.
Yes.
Because of the paid up capital, we know the criteria maximum should be paid up capital is 4 crore, turnover is 40 crore. So what is given here is a paid up capital hint. So 4 crore, which is the maximum amount. Therefore, this company can qualify for fast track. Okay, next.
Now let us change this question. अभी
Okay.
विजय कुमार जी previous slide पर जाइए. Now let us change this question. Now
Okay.
the question is, paid up capital is 5 crores, but there are calls in arrears 1 crore. Then what will happen? On the credit side, paid up capital is there 5 crores,
Yes.
but calls in arrears are there 1 crore.
It will cover, sir.
It will qualify.
Yes.
Yes.
Because the concept here is of paid up capital and not issued capital.
Right.
Yes.
देखो
Yes, sir.
इतनी छोटी छोटी बातें पूछ सकता है वो आपसे.
Right, sir.
Correct. Correct.
चलिए,
So
next.
next is, as per section 57, which of the following is not entitled to make an application for fast track? Director, KMP, promoter, all of the above. You know this, all of the above, all three ABC are not entitled because we have read that. Who
We
is
can
eligible?
again go to section 57 to understand this
Okay.
question.
Yes. Can we go back?
यस यस, आप कंट्रोल होम प्रेस कर दीजिए, होम प्रेस कर दीजिए, एक बार होम से आ जाएगा.
Okay, okay,
ऑन योर
okay.
पीपीटी यू कैन
Sir,
प्रेस होम.
oh,
होम में यू विल गेट यस 57. क्या बोलता है?
by a creditor or a corporate debtor only.
यस. सो
Here,
कौन कौन
here,
एप्लीकेशन लगा सकता है? क्रेडिटर और कॉर्पोरेट डेटर, यही लोग
only
लगा सकते हैं.
252, which means KMP, director, promoter are not there.
If you still feel that corporate applicant can also file, please write. We can also refer to form number 6. फॉर्म नंबर 6 एक बार देख लेते हैं. अजय जी, कैन वी सी फॉर्म नंबर 6 और एनीबडी
Yes,
एल्स?
sir. Yes.
हाँ, आप अपना खोल के रखिए उसको. फॉर्म नंबर 6 देख लीजिए एक बार, क्या बोलता है वो. तो देन विल बी एबल टू अंडरस्टैंड इट बेटर परहैप्स. देख लेते हैं क्या बोलता है फॉर्म नंबर 6. कौन कौन एप्लीकेशन लगा सकता है? And in that case we'll be able to change the option also. देख लेते हैं, let us see. भाई फास्ट ट्रैक का भी एप्लीकेशन लगाएगा तो फॉर्म नंबर 6 ही तो यूज करेगा ना. तो फॉर्म 6 देख लेते हैं क्या बोलता है. इससे पहले ही है, हाँ, यही फॉर्म 6 चल रहा है. हाँ, यही तो है फॉर्म 6. यस,
यहाँ पे लगे, yes.
हाँ, थोड़ा बड़ा कर दीजिए. हाँ, स्लाइड शो करके बड़ा कर दीजिए. क्या बोलता है ये?
सर बड़ा हो गया.
नहीं,
Slide
जूम कर दीजिए ना, जूम करके और बड़ा हो जाएगा. हाँ हाँ, कौन लगा रहा है इसमें एप्लीकेशन देख लेते हैं. इससे ऐसे नेक्स्ट पेज पे जाइए. हाँ, पर इसमें भी कॉर्पोरेट एप्लीकेंट लिखा है तो ठीक है. कॉर्पोरेट एप्लीकेंट कैन ऑल्सो फाइल दिस एप्लीकेशन. ठीक है ना. तो कॉर्पोरेट एप्लीकेंट हो जाएगा तो वी विल चेंज दैट ऑप्शन, है ना. तो नाउ वी स्टैंड करेक्टेड थ्रू दिस कि कॉर्पोरेट एप्लीकेंट कैन फाइल दिस एप्लीकेशन. लिखा ना पर्टिकुलर्स ऑफ द कॉर्पोरेट एप्लीकेंट.
Yes, yes.
हाँ.
The corporate debtor and corporate applicant is one and the same, right? Sir?
No, that is different because these terms are different. Corporate applicant includes KMP, director, etc.
Oh,
And now you might ask where it is written. It is written in, I think, section 5. Section 5, subsection 5. Corporate applicant means corporate data, member or partner who is authorized to make the application, an individual in charge of managing, a person who is the control or supervision. So these are the persons who are included in corporate applicant. Yes, please.
so now
अब
our
इसको
MCQ is what
ये
is
बंद
right.
कर दीजिए अजय जी. उसी पर चलते हैं हम, अपने केएमपी पर वो उसके चलते हैं. यस, विजय जी आप शेयर कीजिए. सो हियर अभी हम क्या करते हैं, लेट अस चेंज दिस क्वेश्चन. सो वी विल गिव ओनली 2 ऑप्शंस, कॉर्पोरेट डेटा, कॉर्पोरेट एप्लीकेंट.
Sir, what is the answer now? Director, KMP, promoter, all of the above. Answer is D we put, which means corporate application includes director, KMP, and promoter.
यस, सो व्हाट वी कैन डू इज वी विल रिमूव दिस और नॉट हटा देंगे क्वेश्चन में से. सो देन ऑल विल बी एंटाइटल्ड. So
Okay.
we will ask the question, which of the following is entitled to make an application. So here what we have now seen after seeing form number 6, okay, who is entitled to make an application? Corporate applicant. And corporate applicant includes not only the corporate data but all these persons also, as per section 5 subsection 5 of IBC.
डरेगा तो
ठीक है जी. चलिए नेक्स्ट क्वेश्चन चलिए. सो व्हाट वी विल डू विजय जी, वी विल
Yeah.
चेंज इन द क्वेश्चन. चलिए नेक्स्ट. यस प्लीज, दिस इज द क्वेश्चन. Yes, Vijay Kumar ji, please.
Yes, yes, sir. Can I share?
Yes, yes, yes. It is already shared. Yes.
Sir, can you hear me?
Yes, yes, yes. Yes, we can very much hear you.
Can you hear me? Can you hear me?
Yes, yes, yes. Yes, we can hear you.
Okay. So, yeah, yeah. Now, next is an insolvency professional was an independent director of XY. Yeah, insolvency professional was an independent director of XYZ Private Limited 2 years ago.
Hmm.
Can he become a resolution professional of
Other
XYZ
participants
Private
can mute
Limited?
themselves.
Yes, no.
है ना? Because क्या होता है वरना इको हो जाता है. Yes, please.
Yeah. So, insolvency professional is qualified to be an independent director of XYZ Private Limited. So, therefore, he is eligible to be a resolution professional of XYZ Private Limited. We have seen that before.
The point here
As per
is
regulation 4.
just a minute. Please go to the previous slide, Vijay ji. The point here
There,
is
sir. Can you
the bar is on the existing directors. The point here is, suppose he was an independent director 2 years ago, or 3 years ago, or 10 years ago. It says is a director. If you see the regulations regarding this resolution professional, so they will say a person shall not be eligible to be appointed if he is a director or if he is a related party. The point here is, if he has been auditor, if he has been a director in the past, then whether this disqualification shall apply or not. This is the question.
Sir, now
Do
the
you
question
agree?
to you is,
Ajay ji?
sir, now, yes, sir.
Yes, sir. He can become a RP because he was independent director to the company in the
Yes.
past previous 2 years.
Right.
Sir, if the
Another
question
question.
is
Let us
changed,
change this question. He is an independent director now. He is an existing independent director. So can he become a resolution professional?
No, he cannot hold a.
No, he cannot, because that will be a conflict of interest.
Yes.
Yes, please. Next.
sir, I want to change this question. Can you hear me?
Yes, yes.
I want to change this question. An insolvency professional was a director of XYZ Private Limited 2 years ago.
Right.
Can he become a resolution professional of XYZ Private Limited?
The question is same, sir, I think.
There is no bar. In that case also there is no bar.
No bar. No bar. Okay,
Yes.
sir. Next, as per regulation 4, without prejudice to section 17(2)(d), an interim resolution professional may assess the books of account, records, and other relevant documents and information to the extent relevant for discharging his duties under the code of the corporate debtor held with a certain class of person. Whether IRP can ask documents lying with the advocate of the company undergoing fast track IRP. Yes, no. Answer is no. Yes, sir. Can you amplify
Yes, the
this?
point is, if we read section 126 of the Indian Evidence Act, so it says any communication between the client and his advocate is a privileged communication. So if an advocate refuses to part with certain documents, because he may say that this is a privileged communication between me and my client. So you ask the document from your client, from the CD, why you are asking me? So he can refuse.
Yes. Next one, as per regulation 6, the public announcement has to be published in one English and one regional language newspaper. You have been appointed IRP of a company having a registered office in Telangana. How will you identify the regional language for publication? Through Google, inquiry from newspaper office, official website of Government of India, any of the above. Answer is official website of Government India.
Because you might be wondering, suppose you become an insolvency professional, those they say a regional language newspaper. So where you will find this regional language? So there is an official website of Government of India which gives which are the regional languages. Yes, please.
Next, beside other information, public announcement made shall provide a last date for submission of, EOI, which shall be 10 days from the date from the from commencement. Okay, proof of claim, fast track commencement date, claims, date of appointment of the interim resolution professional, claims, fast track commencement date, none of the above.
So
Regulation.
what we can do is we can break this question into two parts. Number one,
Oh,
public announcement shall provide the last date for submission of. So whether it is proof of claim or claims or what. This is, so you can open regulation number also, regulation 62C of the fast track regulations. It is there in this PPT itself. तो एक बार खोल दीजिए विजय कुमार जी.
yes, sir.
हाँ. अब next चलते रहिए. You will go to regulations 62C. Yes. Next. हाँ चलते रहिए. Yes, yes. Yes, after that. Yes. और चल दीजिए. This is the case law. Yes. 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 और चलिए नीचे. हाँ. Yes, these are the regulations. So 62C. This is number 3, 4, 5, 6. Yes. 5, 6.
Yeah.
Just
this
prior
is,
slide.
Prior slide. Okay, sir. This
Previous
is
slide. 6 था ना? 62C.
62C, sir. I am showing C.
Yes, yes, yes.
Provide the last date for submission of proof of claim.
So
Shall
the
be
it is
days-
here. It they say submission of proofs of claim.
Claims.
So if they give you two options, whether for submission of claims or proofs of claim, so you have to select proofs.
Proofs of claim. Proofs of claim.
Yes.
Yeah.
Yes.
So
And it will be 10 days from the
proof of claim.
नहीं submission of proofs of claim तो हो गया है ना.
Correct.
And second is which shall be 10 days from the, ये भी देखना 10 days कहां से लेना है आपको. 62C एक बार देखते हैं तो I can read it from the book also for your reference.
Yeah, yeah, sir.
So it says 10 days from the date of appointment of the IRP.
Means
Yes.
commencement of this fast track insolvency process.
हाँ नहीं इसके अंदर ऑप्शन क्या आएगा. Fill in the blanks which shall be 10 days from the date of appointment of the IRP. है ना. तो इनमें से कोई भी ऑप्शन करेक्ट नहीं हुआ दोनों के लिए.
Yeah, it should be proof of claim plus date of appointment of the 10 days
Right. हाँ.
Yeah. from the date of appointment of the interior professional, which is
Right.
not there in
Yes. So none of the above is correct.
none of the above is the right answer.
Yes. Next.
Once an interim resolution professional has constituted a committee of creditor, he shall inform the following person regarding the constitution of the COC.
So the constitution of the COC has to be intimated to whom? This is the question basically.
Yeah.
So
Adju-
regulations, because we have already read the CIRP regulations and they are somewhat similar. So that is why it is very easy to understand. So regulation 17.1 gives you an answer. So if you read regulation 17.1, what it says? किस किस को intimation देना है? To whom you have to intimate? Suppose you have constituted a committee.
Adjudicating authority.
Yes, to the adjudicating authority on or before the expiry of 21 days. So the answer will be
B.
yes, adjudicating authority.
Next, as per regulation 37.3 explanation 2, which of the following shall not be covered under connected person? A person who are promoters in the manager or in the management and control of the resolution applicant, person who will be a promoter and in management control of the business of the corporate debtor, person who had been the promoter and in management and control of the business of the corporate debtor 5 years ago, or the last option, none of the above. So the answer is C, person who had been the promoter or in management and control of the business of the corporate debtor 5 years ago, or the people who are
Actually-
not covered under definition.
Actually,
of-
under connected person, you
Hmm.
include only the present promoters or prospective promoters. Who are prospective promoters? Prospective promoters are those who are indicated in the resolution plan that they will be taking over the company. They will be managing the company. So for identifying connected persons, you have to look at the persons who are promoters. So this is with reference to resolution plan, resolution applications, resolution applicant. So in resolution applicant, if you want to identify who is a connected person, so first of all, you will see that he is not the present promoter or he is the promoter. Second is who will be the promoters when this plan will be implemented. But suppose a person was a promoter in the past or he was in management or control. So that is no bar. So that person will not be covered under the connected persons. The question is negatively worded. Shall not be covered. Who shall not be covered? So person who was there in the past as a promoter or in management or control, so he will not be covered under the connected person. This is the meaning. So we have to remember that under the connected persons, we have to look for persons who are either promoters or in management or control in the present, or they will be promoters or management control once the resolution plan is implemented.
Sir, future promoter also.
Yes,
covered?
yes. Who will be aage na? Who will be? Second point is okay.
Will
Second
be a
covered.
resolution applicant, right, sir?
Right. This is with reference to resolution applicant.
So they are called connected persons.
Yes, yes, yes.
Okay.
Actually, for resolution applicant, you have to see the eligibility or ineligibility not only with reference to the person who is submitting, but with reference to the connected persons also.
Correct.
Yes.
So as per regulation 25(4), the resolution professional shall circulate the minutes of the meeting by electronic means to all members of the committee within 48 hours of the conclusion of the meeting, and seek a vote on the matters listed for voting in the meeting from the members of the committee who did not participate in the meeting or did not vote at the meeting, if any, by electronic means or by electronic voting system, where the voting shall be kept open for from the circular dash from the circulation of the minutes, at least 24 hours, maximum for 24 hours, 24 hours, any of the above.
So the point is, sometimes you remember the 24 hours is there, but you don't remember beyond that. So they will probe you further by whether it is prefixed or suffixed with any such thing. 24 hours you may remember, like 66 you may remember, but whether 66 is at least or not more than 66, not less than 66. So they will ask you questions like this.
Okay.
So under CRP, that it is mentioned as at least for 24 hours.
So that is why यहाँ fast track है ना, we are now reading fast track. So we have to answer regarding fast track only.
So only 24 hours, right? C.
हाँ बिल्कुल यही तो फर्क है ना, इसीलिए क्वेश्चन पुट किया गया स्पेशली.
Okay.
भाई हमारे when we are reading fast track, तो हमें तो we have to give reference of the fast track only ना.
Correct.
CIRP में क्या लिखा है वो अलग चीज है ना. ये तो उसके छोटा भाई है ना CIRP का, ये छोटा भाई है फास्ट ट्रैक.
Correct.
Yes, please.
So next one, as per regulation 22, the quorum at the meeting. A meeting of the committee shall be quorate if members of the committee representing at least 33% of the voting rights are present, either in person or by video conferencing or other visual means, provided that the committee may modify the percentage of the voting rights required for a quorum in respect of any future meeting of the committee. That is right. What does the term modify mean here? This is a regulation. What we read is a regulation.
Yes.
They are asking, what does the term modify mean here? One, increase or decrease, decrease, or any of the above. The answer is A. So modify means the committee can decide less than 33% also, more than 33% also.
Right. Yes.
So committee has the power to increase or decrease the quorum requirement. Next, as per regulation 37 of the resolution plan shall include certain detail in respect of resolution applicant and other connected person. Which of the following detail is not covered in such details? Point number 1, civil proceeding pending, if any, transaction with the CD in preceding 2 years, both A and B, None of the above. So what is not covered in such details, right, shall include certain details. It's written in Regulation 37. The civil proceeding pending is not covered.
Actually, you have to include only the criminal proceedings.
Ah.
So this way, when you attempt these MCQs, now you will be able to remember some of the provisions.
Correct.
So indirectly, you also remember that only criminal proceedings are to be included in the details.
Not the civil proceeding.
Yes.
Next, XYZ Private Limited started its operation in April 2014.
So this is a case study. Yes.
This is a case study. It is registered as a startup with the DIPP. Its turnover during the financial year was 80 crores. Its investment in plant and machinery was 50 crores. It incurred a default of rupees 2 crores in the month of November 23. Based on the above facts, please answer the following question.
Now, just before we attempt this, please go to previous slide. So it says its turnover is 80 crores. The point is we might feel confused here that we have read about turnover as 40 crores only. So where
Yes.
from this 80 crores is coming?
Yes.
The point here is that besides a small company, there are other categories also, like startup. So now, before we attempt this case study, let us see the definition of startup also. Startup का next देख लीजिए, इसके बाद में आ जाएगा, थोड़ा flip कर लीजिए some slides. Let us go to the slide regarding startup. ये just skip this case study. इससे next चलिए. हाँ, after this startup कहाँ पर भी है? You can do some control F also.
Oh.
नहीं तो वैसे कर लीजिए, कोई बात नहीं. हाँ, जस्ट गो थ्रू. आप देख लीजिए, यू विल फाइंड द डेफिनेशन ऑफ स्टार्टअप आफ्टर दिस केस लो. Yes, next. Small company we have covered. Yes. Yes. Next. Yes, this is the definition of startup. Yes.
Yes.
Yes. So first of all,
An entity shall be considered as a startup if it satisfy the following condition. If it's incorporated or registered as any of the following: private limited company, partnership firm, limited liability partnership, registered under the Limited Partnership Act 2008, one-person company as defined in Companies Act, provided such entity is not formed by splitting up or reconstruction of business already in existence. It has not completed 10 years since incorporation as above. Its turnover for any financial years has not exceeded 100 crores. So which means 80 crores satisfy the application. It satisfying any of the following condition. It's working towards innovation of new products, process or service, development of new products, process, service, improvement of existing product, process, service. It is a scalable business model with high potential of employment generation or wealth creation. This is
so
all.
another question here crops up, whether a listed company could be covered under startup.
No.
Why?
Because it's defined here.
No, they have not written listed company. About listed company, they have not written any such thing.
Because
so what is the logic? Give me the logic.
There is a concept of 3 year. One company can only get listed if it is 3-year-old.
They are saying companies up to 10 years can be covered under startup. Then where is the hitch? Give me some logic. The answer is correct, but give me the logic. The logic I would give is that only private limited company is covered. So listed company cannot be a private limited company.
Correct. It is excluded.
Okay.
क्यों अजय जी? नहीं
Right.
है ना? हाँ. तो अभी देखिए, now regarding startup also it is clear.
Yes. So many things we have to take it up from the definitions.
The private limited startup can be a private limited, a partnership firm, or LLP, or one-person company.
But another point is, if it is a partnership firm, whether you can file an application for fast track process? The answer is no, because here only corporate persons are covered. Actually, this is the general definition of startup, which is given by Department of this Promotion Policy, etc. So that is Department of Industrial Policy and Promotion. So that is the definition actually, which is given under the startup. But they are referring to partnership firm also. So they can ask you this question also, whether a partnership firm can apply for fast track insolvency resolution process. The answer is no, because only corporate persons are covered.
Correct.
Individual and partnership firms are referred to apply for with the DRT. I think they have to go DRT for this resolutions.
हाँ, वो फास्ट ट्रैक में तो आएंगे नहीं ना. फास्ट ट्रैक इज ओनली लिमिटेड टू कॉर्पोरेट पर्संस. इंडिविजुअल्स के लिए तो फास्ट ट्रैक है ही नहीं.
Right.
But LLP can apply, right, sir?
यस, हाँ, एलएलपी पे तो कोई बात नहीं.
LP is
लिखा हुआ है.
Yeah.
यस, अब चलिए केस स्टडी पर. यस, इससे पहला जस्ट
So I will get the case study.
यस, दिस इज द स्लाइड.
Yeah, this is a slide. Its investment in plant and machinery was 50 crore. It incurred a default of 2 crore in the month of November. Based on the above, please answer the following questions. What are the options available to XYZ Private? It can go for pre-pack, fast track, CRP, or any of the above. Answer.
So the first question, whether it, please go to previous slide again. Whether it can go in for CIRP. CIRP में जा सकती है क्या ये, या नहीं जा सकती?
Yes, it can, sir.
हाँ, है ना. CIRP में कोई दिक्कत नहीं, क्योंकि डिफॉल्ट अमाउंट इज 1 crore और मोर, है ना. सो CIRP में भी जा सकती है, एंड इट कैन गो इन फॉर फास्ट
fast
ट्रैक
track.
ऑल्सो. फास्ट
Fast track.
ट्रैक वाई? बिकॉज इट इज रजिस्टर्ड एज ए स्टार्टअप, है ना. सो दिस इज द रीजन इट कैन गो इन फॉर. वेदर इट कैन गो इन फॉर प्रीपैक. प्रीपैक में भी जा सकती है क्या? Although we have not read pre-pack as of now, pre-pack is applicable only to
SMEs.
MSME sector, MSME, corporate MSMEs.
Correct.
And only a corporate debtor can file the application under this pre-pack process. The creditors cannot file the application.
I believe for SMEs, the criteria is fixed for 50 crore of turnover, right?
Right. So it is very well covered there also.
Hmm.
Yes, please. So they can ask you questions like this also. So it can go in for pre-pack, it can go in for fast track, it can go in for CIRP. Now they will weigh the options, which is beneficial. What are the benefits? In case of pre-pack, it is something similar to one-time settlement scheme. So in case of pre-pack, the control remains with the existing directors. So definitely they will prefer pre-pack process. Fast track is for small companies, and CIRP is much more detailed. So the first option will be pre-pack only, if pre-pack is available. If pre-pack is not available, then out of fast track and CIRP, I think fast track will be beneficial. It will be preferred because it is a faster, quicker process.
Quicker process.
Yes, next.
So the answer is
Answer is D, any of the above?
any of the above. Correct. So next is XYZ Private Limited decided to file an application under fast track. Which of the following is not mandatory document to be attached with the application? Evidence of default, because this is a negative question. Proof of serving a copy to the corporate debtor. Proof of serving a copy to the board. None of the above. Answer is
आंसर तो इसका लास्ट में दिया गया है.
Sir, C, proof of serving a copy to the board is not mandatory actually.
not mandatory.
The answer would be C, I believe.
तो इट इज नॉट मैंडेटरी. बोर्ड को कॉपी देना जरूरी नहीं है आपके हिसाब से,
नहीं सर,
है?
नहीं.
तो एक बार देख लीजिए आंसर क्या लिखा है. So for finding the answers, you will have to go to the rules, application to adjudicating authority rules. एक बार रूल्स खोल दीजिए अजय जी.
I think none of the above will be.
हाँ, तो एक बार कॉपी, एक बार खोल दीजिए ना, एप्लीकेशन टू एडजुडिकेटिंग अथॉरिटी रूल्स खोल दीजिए, पता चल जाएगा. ये शुरू में रूल्स दे रखे हैं आपको, रूल 4, 5 वगैरह, क्या क्या लगाना है आपको, वो रूल्स दे रखे हैं. इससे क्या होगा, पढ़ना भी आ जाएगा ना, मेन बात ये है. रूल 4 देख लीजिए एक बारी.
Answer is C.
हाँ, इसको बड़ा कर लीजिए. हाँ, एप्लीकेशन बाई फाइनेंशियल क्रेडिटर. क्या करना है? कॉपी किस किस को देनी है देख लीजिए.
The applicant shall serve a copy of application to the registered office of the cooperator and to the board. अच्छा, board को भी लिखा है.
हाँ. है
और
ना?
बाय हैंड और बाय इलेक्ट्रॉनिक मीन्स सीआरपी में नहीं करते हैं. बिफोर फाइलिंग विद द एजुकेटिंग अथॉरिटी.
हाँ, और ऐसा ही उसका भी होगा, ऑपरेशनल क्रेडिटर का भी होगा. वो आगे
डिमांड.
रूल मिलेगा शायद 9 है क्या, कौन सा रूल है देख लीजिए. आगे और रूल होगा. ये तो डिमांड आ गया ना, फिर आगे होगा. वही वही पर चलिए. हाँ, कौन सा रूल है? ये 6 देख लीजिए. हाँ, तो 6 में किस किस को कॉपी देनी है?
No, shall make an application for initiating the CIRP against a cooperator under Section 9 of the Code in Form F, accompanied with the documents and records required therein as specified in the IBC Insolvency IBC Board.
हाँ, 2 पढ़ लीजिए. 6 का 2 पढ़ लीजिए, क्लियर है.
Shall serve a copy of the application to the registered office of cooperator and to the board also.
और
By the
कॉर्पोरेट एप्लीकेंट किस किस को दे रहा है? कॉर्पोरेट एप्लीकेंट भी दे रहा है. कॉर्पोरेट एप्लीकेंट खुद को तो
same
देगा
same
नहीं, तो
applicant to the
कॉर्पोरेट
board.
डेटा तो खुद ही है,
Yes,
बोर्ड को
yes.
दे देगा.
Board.
है ना जी? तो बोर्ड को कॉपी देनी है. चलिए, इसको बंद कर दीजिए. चलिए विजय जी, अपना खोलिए. यस.
Sir, we go further or? Sir, what is the answer for Q2? Question.
आप देख लीजिए. नाउ यू हैव रेड द रूल्स. So copy you have to give to the corporate debtor. You have to give copy to the board also.
तो इसमें आंसर वुड बी द बी एंड सी.
आंसर तो डी होगा ना. नॉट ए मैंडेटरी डॉक्यूमेंट.
बी और
सारे
सी तो
मैंडेटरी
मैंडेटरी
है.
हो गया.
ओके.
सारे ही तो देने हैं ना. तो आंसर तो डी हो जाएगा ना इसका.
ओके.
यस विजय कुमार जी, यू वर सेइंग समथिंग.
No, the answer is D, sir.
हाँ, डी शुड बी द आंसर.
Okay. So it's not mandatory.
No. It says it is not a mandatory document. So all are mandatory. A is mandatory. B is mandatory. C is mandatory.
Okay. Okay. Done. Okay, understood. You know how to read the question.
Sometimes, even when we know the answer, we answer it wrongly in the examination.
Correct.
That is the catch.
Sir, what about evidence of default? It is
डिफॉल्ट तो देना ही है. डिफॉल्ट के बिना तो एप्लीकेशन
Okay.
एडमिट होगा. 1 करोड़ का डिफॉल्ट तो देना ही है.
okay, sir. Okay, thank.
और क्या?
Understood.
Okay, sir.
Question number 3. By what date can the application be filed? Within 14 days from the date of default, within 3 years from the date of default, within 1 year from the date of default, within 7 years from the date of default. By what date can the application be filed? The answer is B.
Answer is
B.
but it has to be filed within the limitation period.
Yeah, within the limitation act you have to file.
Yes.
Within 3 years.
Q4, can a CRP application be converted into fast track? No, yes, no, but vice versa is possible. Yes, with the approval of A. Which one is the right answer?
So no.
Right, very correct. But a fast track could be converted into CIRP.
Okay.
Fast track could be converted into CIRP, but CIRP cannot be converted into fast track.
Excellent. Question number 5. Suppose it is converted into normal CRP. In that case, it will be treated as an application under section 7, 9, 10, or any of the above.
Any of them.
Yes, here the provision is different from pre-pack. In pre-pack, suppose pre-pack is converted into normal CIRP. Pre-pack can also be converted into normal CIRP. Then it is treated as section 7 application.
Correct.
But here it is not so because application is different. Application that is already covered under the respective sections. Yes, please. Next.
How many registered values have to be appointed in case of fast track IRP? 1, 2, 3, or as per the recommendation of
D. D is correct answer. I think.
नहीं रेगुलेशन नंबर बताइए ना सर.
I believe 2 people. B.
मेरे को तो लग रहा है 1 होना चाहिए. आप रेगुलेशन नंबर देखो ना सर.
जी sir.
और सबसे बढ़िया क्या कर सकते हैं आप? व्हाट यू कैन डू इज यू कैन डू कंट्रोल एफ वैल्यूअर रेगुलेशन में पता चल जाएगा आपको.
It depends upon value.
Actually, the point here is regulation number 26. So 26 says the resolution professional shall within 7 days of his appointment appoint one registered valuer. So they have written one.
Registered value.
Regulation 26. In CIRP it is 2. And even if with he is not satisfied with 2, he can appoint third also. In
Yes.
liquidation it is only 2.
Yes.
So in IBC chart, which I have given you as an Excel sheet, I have given this comparison also between the various processes, and you have to remember all these things. In CIRP, normally it is 2, but it can be 3 also. In liquidation, it is 2 only. There can't be third, and here it is 1.
Wow.
Regulation number 26 of fast track regulation. With appoint one registered valuer. So 1 means 1.
Yes.
So answer will be A here.
Yeah.
तेरे ब्रैकेट में जो उसमें लिख रहा है अपॉइंट 1 रजिस्टर्ड वैल्यूअर, ब्रैकेट में लिख रहा है 2 और 3 इन अदर केसेस. अदर केसेस कौन से आगे?
कहाँ लिखा है?
26 नंबर जो है अपॉइंटमेंट ऑफ रजिस्टर्ड वैल्यूअर 26 नंबर, उसमें पढ़ के सुनाता हूँ. द रेजोल्यूशन प्रोफेशनल सेल विद इन 7 days ऑफ हिज अपॉइंटमेंट.
2 and 3 covered under CIRP ना.
2 and 3 कहाँ लिखा है? कौन सी किताब से पढ़ रहे हो आप? मैं तो
आपके
से पढ़ रहा हूँ.
नहीं, आपका जो पीपीटी है सर उसी में पढ़ रहा हूँ. 378 नंबर पेज है, उसमें ये 26 नंबर पॉइंट है अपॉइंटमेंट
अरे
ऑफ
वो
रजिस्टर्ड वैल्यूअर.
मैंने एक्सप्लेनेशन के लिखा है 2 और 3 इन अदर केसेस मतलब CIRP या लिक्विडेशन.
ओके.
दैट इज जस्ट फॉर अंडरस्टैंडिंग पर्पस.
ओके.
हाँ, यहाँ पर 1 नहीं है.
Number 7 now. Invitation of resolution plan has to be given by at least 21 days before the last date for submission of the resolution plan. At least 30 days before the last date for submission. So at least 15 days before the resolution, at least 45 days before the last date for submission. The answer is B, 30 days.
B तो नहीं लग रहा मेरे को, तो C लग रहा. देखो
CRP में C है सर, 15 days रहता है. आई एम नॉट अवेयर अबाउट दिस फास्ट ट्रैक.
आप यहाँ देख लो ना, इन्विटेशन ऑफ रेजोल्यूशन प्लान्स. आपको टाइमलाइंस भी तो दिया है मैंने.
टाइमलाइंस में देखिए.
Yes.
So timelines also I have given. Invitation of resolution plans. 35A1. Regulation number 35A, sub regulation 1. At least 15 days before the last date of submission. So answer will be C.
Answer is C. Sir, the answer is C.
Regulation 35A, sub regulation 1. So whenever you answer, you have to see you have to again read the regulation, and you have to write the regulation number also in your answers.
Yeah.
So that way you will be able to read it again. That is the purpose. You need not remember the regulation number. That is not the intent. The point is to read it again.
Oh. Sir, this is for all the chapter 2, sorry, part 2, right, sir?
Right. Yes.
Yeah.
So regulation 35A, sub regulation 1. Yes.
Yeah. Question number 8. What is the last date for approval of the resolution plan? 30 days from the request of resolution plan, from the issue of request for resolution plan, 21 days from the issue of request for resolution, 15 days from the issue of request for resolution, 45 days from the request for issue of plan. Answer is $30 days, sir. A. What is the regulation?
Regulation number देखिए.
38. So
38 में है वैसे तो अप्रूवल ऑफ रेजोल्यूशन प्लान, बट इसमें लिख रहा है कि विद इन द टाइम गिवन इन द इनविटेशन मेड।
हाँ
टाइम गिवन इन द इनविटेशन मेड मतलब कोई सेपरेटली कुछ नहीं किया लग रहा है।
बट इसका इनडायरेक्ट आपको आंसर मिल जाएगा। भाई 90 डेज में तो पूरी राम कहानी कंप्लीट करनी है। विद इन 90 डेज यू हैव टू कंप्लीट द एंटायर स्टोरी एंड
Yes.
15 डेज यू हैव टू गिव टू द एडजुडिकेटिंग अथॉरिटी।
Yes.
75 days.
हाँ इनडायरेक्टली हो गया ना।
Right. 15 days from the issue of the
नहीं नहीं 15 डेज का जरूरी नहीं है। आप यू हैव टू सी कि व्हाट इज द लास्ट डेट फॉर इश्यू ऑफ रिक्वेस्ट फॉर नाउ यू नो द आंसर। फर्स्ट थिंग इज व्हाट इज द लास्ट डेट फॉर अप्रूवल। अप्रूवल इज 75 days. Now out of 75 you deduct what is the last date for issue of request for resolution plan. So then you will be able to find the answer.
So the 90th day is the day where they should approve the plan maximum.
That is for A, double A.
That is
Right.
for
Will
double A
approve.
ना।
Double
Here
A will approve
here
in
it is
90
for
days.
COC. ये तो COC अप्रूव करेगा ना।
COC के लिए 15 दिन कम कर दी तो 75 हो गया।
हाँ अब 75 में से now you find out what is the last date by which issue of RFRP can be made.
45 days.
हाँ तो 45 75 minus 45 जो आंसर हो जाएगा।
30 days. 30 days.
चलिए नेक्स्ट।
So which of the following is not mandatory content of the resolution plan? Transaction, if any, with the CD in the preceding 2 years. Civil proceeding, if any. Conviction for any offense, if any, during the preceding 5 years. Final one, none of the above. Which one is right?
The mandatory contents they are given in regulation number 37.
Here A will be the transaction, if any, with the CD in the preceding 2 years.
None of the above. D.
देख लेते हैं।
देखो जी कन्विक्शन तो कवर्ड है, ठीक है,
सिविल प्रोसीडिंग्स भी कवर्ड है।
क्रिमिनल प्रोसीडिंग्स कवर्ड है, हैं? और ट्रांजैक्शंस भी कवर्ड है। ट्रांजैक्शंस इफ एनी विद द सीडी, ये
सिविल प्रोसीडिंग कवर नहीं है।
बस हाँ
civil proceeding, not
यस, तो बी आंसर हो जाए।
B and B is
ट्रांजैक्शंस इफ
correct.
एनी विद द सीडी प्रीसीडिंग 2 years में कवर्ड है ये।
Civil proceeding.
क्रिमिनल प्रोसीडिंग
not
कवर है,
right.
सिविल प्रोसीडिंग कवर नहीं है।
हाँ बस बस हाँ। तो 37 में ठीक है जी। तो कौन सा बचा? सिविल बच गया, बाकी तीनों देने ही आपको। चलिए नेक्स्ट क्वेश्चन देखिए।
So the answer, sir, the
Answer is
answer
B.
is
आंसर इज बी।
Right.
चलिए नेक्स्ट देख लीजिए। आई थिंक दैट विल बी द लास्ट क्वेश्चन फॉर टुडे।
the information memorandum need not be shared with the suspended board of director, register values, members of COC, IBB.
किसके साथ शेयर नहीं करना?
Need not be shared with
Registered
suspended
value.
board of registered
Value
value,
absolute.
member of COC.
IBBA,
यस आई थिंक आईबीबीआई शुड बी द राइट आंसर।
वैल्यूअर से भी नहीं करते हैं,
है हाँ
वैल्यूअर के साथ भी नहीं करते हम लोग।
हाँ, तो बस वैल्यूअर को नहीं किया और आईबीबीआई को नहीं किया, तो बी और डी हो जाएगा आंसर इसका। दीज आर द आंसर्स।
आईबीबीआई को डिस्क्लोजर देते हैं, राइट।
हाँ
B and D.
हाँ, तो ठीक है, आई थिंक वी कैन स्टॉप हियर। आज बहुत अच्छा डिस्कशन रहा है कि नहीं?
Thank you.
एंड आई
Yes,
थिंक
sir.
एंड दिस वे वी हैव कवर्ड द एंटायर फास्ट ट्रैक। देखो कितने जल्दी हमने कर लिया,
Right.
ठीक है
Fantastic.
नहीं? ऑल्दो वी कैन गिव इट अनदर डे आल्सो, नो इश्यूज,
Sure.
because sometimes they frame a case study on this fast track only,
Okay.
so we should be able to answer it,
And answer.
है ना? फास्ट
Okay,
ट्रैक
sir.
पर कई बार क्वेश्चन पूछ लेता हूँ, दे फ्रेम अ केस स्टडी इस पे, So I think we can stop here. Thank you so much.